I don't know if it's automatic, but to me, it's more like, as Judge Fletcher says, it's within everybody's common understanding that, you know, if you don't have a toothbrush, if you don't have soap, if you don't have a blanket, it's not safe and sanitary. Well, wouldn't everybody agree to that? Do you agree to that?
Well, I think there's fair reason to find that those things may be part of safe and sanitary.
Maybe, are a part. What do you say maybe? You mean there are circumstances when a person doesn't need to have a toothbrush, toothpaste, and soap for days?
Well, I think in CBP custody, it's frequently intended to be much shorter term. So it may be that for a shorter term stay in CBP custody that some of those things may not be required.
Yeah, but I don't think that was the situation that the court was confronting. I mean, it wasn't as though those people were there for 12 hours and then moved on to the Hilton Hotel. No, they were there for a fairly sustained period, and at least according to the evidence that the judge believed, they weren't getting these things for a fairly sustained period.
Well, I do want to clarify that the judge did find that in Ursula, in one of the CBP facilities, that many of those things were present,
Right.
and that the evidence did show that that minors spent a much shorter period of time. There was only a small percentage of minors who weren't moved to Ursula very quickly.
So just to clarify, at some point in your brief, you appear to be saying that safe and sanitary has no independent meaning, and that there's another sentence that follows it that has some details, and that's the only thing you're required to do. I don't understand you to be arguing that now. Is that correct? That's what your brief said, right? Your brief seemed to say that safe and sanitary had no independent meaning.
I don't think it has no independent meaning, and if that's the impression our argument gave, I apologize. I think that the position is more generally that to impose specific enumerated meanings that are not contained in the agreement, without in fact reaching the ultimate question of were the conditions overall in general, as a general matter, safe and sanitary, is not a correct finding of breach.
No, but you see, under that approach, if the district court were to conclude no, they were not sanitary, and all it could do is say fix it, they can tell you what to do, right? They can say you have to provide soap. All they can do is issue an order saying make it sanitary, right? I mean that's what these details are there for. Isn't that the purpose, to give concrete meaning to the term?
I think.
I mean, you know, if CPB got an order saying, you know, we want your facilities to be sanitary, they say fine, we'll make them sanitary. But you know, I mean, who knows what sanitary is?
And I think that then goes to whether to what level the agreement could be enforceable. That's partly what I'm getting. So you're saying maybe the agreement is so vague that it's unenforceable. That's almost your argument, isn't it? To some extent, yes, Your Honor. I think that if the term in the agreement requires an after agreement interpretation by the district court, then yes, that does constitute a vague term that the parties didn't sufficiently clarify in reaching agreement.
You know, let's hear from the other side, and we've taken you 18 minutes